And I'm so glad you could join us this evening on this lovely weather. I have to commend the program committee because in October, they planned this to be a Zoom meeting. So I think that shows a lot of foresight. This meeting about civil liberties and the Supreme Court is certainly a timely thing, as we know all the things that are going on with the Supreme Court right now. And Ed has spoken to us last time in 2018 and always been very informative and very educational. So we are looking forward to this. We are recording the program, just so you know that, and so it will be on our website within a couple weeks. Ann Swanson, who is our co-VP of programs, is going to introduce Ed, and she's also going to take the questions that are in the chat. And when the conversation with Ed is over, when he's done with this presentation, we will be asking those questions. And then Ann will end the conversation. So Ann, take it away.
Good evening. Thanks for joining the meeting. I'm really excited about this because as a former attorney, I still am very interested in what the Supreme Court is doing and our civil liberties. Just as way of background, Ed is the Director of Communications and Public Policy for the ACLU of Illinois. He was appointed to that post in June of 1999. He regularly appears on television and radio throughout Illinois to speak of a myriad of issues. And he's also widely cited in newspapers and other publications on legal and legislative matters relating to the ACLU. In 2013, he served as vice chair for the Illinois Unites for Marriage, diverse, multifaceted coalition of organizations that helped win the fight to ensure the freedom to marry for all couples. And from 1987 until 99, he was on the staff of the American Bar Association. So without further ado, Ed, we are looking forward to what you're saying. Oh, and if everybody could stay on mute, and please put your questions into the chat, and I will read them to Ed later.
Great. Thank you, Ann. Thank you all so much. It's a pleasure to be with you all tonight. I will say, to pick up on the theme of earlier, it's really, really good to be here in my office doing this and not having had to drive out to Naperville tonight. So I'm happy for that. I want to talk, as I said, as the title indicates, a little bit about civil liberties and the Supreme Court of the United States. Take a look at where the court is at. Take a look at not just some cases that are upcoming, but I really want to try to focus a little bit on some of the trends we're seeing and a little bit about what's driving some of those trends. And so I hope, at least at the beginning, to keep this a little more big picture. Again, I'm going to try to limit myself at the beginning and engage your questions, because I think that will be the much more interesting conversation than just listening to my own voice. I thought it was probably important to begin by talking a little bit about the ACLU and our role with the Supreme Court. As you know, the ACLU was founded more than 100 years ago to protect civil rights and civil liberties. We have, over that time, been incredibly active in the Supreme Court of the United States. A couple little factoids to that effect. First of all, other than the federal government, the ACLU appears more regularly in the Supreme Court each year than any other entity in the United States. That's either through amicus briefs or as directly representing clients. We have cases, virtually every day. We actually filed a brief in the Supreme Court today in a case our national office did. And the other thing is if you think about the role of the courts in protecting fundamental rights, consider this. In 1920, when the ACLU was founded, the Supreme Court of the United States had never once issued a ruling in which it upheld the free speech rights of an individual over the government. Today, we can't even imagine that. That's happened with great regularity a number of times in ACLU cases. So the courts really play a critical role in terms of protecting our individual rights, our civil liberties, and civil rights, and in terms of advancing our society more broadly by applying the constitutional provisions to more and more people. And that has really been the history and the scope of the Supreme Court throughout much of the 20th century and into the 21st century, clearly in the second half of the 20th century and into the 21st century, is this continued expansion of protections and rights being extended to more and more individuals in our society. And that role, I think, is something that over that period of time, number one, I think people became very dependent upon. We often look to the courts as a way to correct ills within our political system, within our civic system, that when the politics of the country didn't work, we could depend upon the Supreme Court or the federal courts to get it right, to set things correct, and to make sure that people had the ability to express themselves, to be themselves, to marry the person they love, to not be discriminated against on the basis of actions by the courts. But that's beginning to change, and it's really changed, I think, not by not by happenstance, but as we've seen, really by a 30-year effort to change the personnel on the court and to put in place justices who adhere to an ideology and a principle that seeks to shrink or limit rights as opposed to expand them. And so the court that, as I say, we often relied on to be the one to expand our basic rights is now one that's shrinking those rights. And I just to explain this, or to sort of build on this just a little more, I'm going to talk about a principle or a theory that many of you likely have heard or heard discussed, which is the notion of originalism, the notion of, a majority of the justices now on the Supreme Court who suggest that they will only interpret the Constitution as it was originally written and intended. That is the only thing that they can do, that is the proper role of the courts. And that shrunken view of an 18th century document guiding us misses a couple of different things, which I think are critical and important. The first of which is that it often reads out of that originalist notion the 13th, 14th, and 15th Amendments that actually sought to set in place an expanded vision of who was protected by our Constitution. So if you're only reading the First or the Second or the Fourth Amendment in accordance with what was happening at the time of the framing of the Constitution, then you're not reading in the principles and the elasticity, as it were, that was written into the 13th, 14th, and 15th Amendment. These amendments, which after the Civil War sought literally to correct the wrongs of the original Constitution, are now being read out of the Constitution by justices who say that they are only limited to the Constitution as it was originally drafted. And that kind of shrinking is having a profound impact on the way that the court is responding to issues that become before it. The other, forgive me, but I suppose I can only describe it as the other 800-pound elephant in the room, is the fact that the Supreme Court today is undergoing a challenge to its credibility caused by ethical issues on behalf of some of the justices that have led many Americans to kind of question the legitimacy of the court. And I think that when you see those two issues operating together, a shrunken ideology which seeks very often to actually reach conclusions over actual analysis, and the ethical questions that have been raised about members of the court, what we're seeing in many ways is a court which is, kind of lurching forward and viewed with less favorability by Americans today than at almost any time in its history. So let's talk a little bit about how those basic rights, and as we think of them as the ACLU, these some of basic rights in some basic areas where the Supreme Court is really beginning to infringe and beginning to wear away at some really fundamental rights in our society. And the first one that I want to start with, and one that probably many of you have followed in the court, is its jurisprudence around voting rights in particular. The history of voting and access to the ballot in the United States is an interesting one because, of course, we for so long limited the capacity of people to vote based on their gender and based on their race and based on even on whether or not they own property. And if you look in many ways, Congress sought to address these issues in the wake of both the 13th, 14th, and 15th Amendment, and then the 19th Amendment allowing women the right to vote, when it came to 1965 and the passage of the Voting Rights Act. And if you take a look at participation by people of color at the ballot, there is a direct line which begins in 1965 with the passage of the Voting Rights Act and takes an upward trajectory to 2012 to the re-election of Barack Obama, when more people of color participated than at any time in our history. And in 2013, following that seminal election, following that kind of high watermark, the Supreme Court begins to act almost immediately to limit the capacity of people to have access to the ballot. So in 2013, the Supreme Court issues a decision in Shelby County versus Holder, in which the court simply declares that the definition that was required, the definitions that were approved by Congress in renewing the Voting Rights Act in the early 2000s didn't have enough research behind them, didn't have enough evidence behind them to suggest that some jurisdictions, states, and other areas across the country that had a history of limiting voting rights, the court said that those states and those counties and those states no longer had to be subject to pre-clearance because, quote, there was no evidence that people were being denied the ability to vote based on race. John Roberts, the Chief Justice, in his opinion in that case, literally says that America's race problems have been solved by the fact that we elected the first Black president of the United States. That wasn't true. And almost instantaneously, the states that had previously been subject to the provisions of the Section 5 in particular of the Voting Rights Act began to make changes to their voting systems that began to limit the capacity of people of color, in particular, elderly people and young people, to vote. So we see things almost instantaneously, like in Texas, the implementation of a voter ID scheme that allows you to vote with your firearms registration card, but not your student ID from the University of Texas at Austin. We saw in North Carolina the limitation on the ability of people to early vote on Sunday, which was a traditional day that African Americans in North Carolina would engage in what many of you have probably heard of, a practice of so-called souls to the polls, where large Black churches would rent buses, have their congregants come to services, and then bus them to the electoral site to vote, and then bus them back to their cars at the church. Those days were eliminated, driving down the number of people of color who participated. And we see this across many areas of the country that had previously been covered, and all under this theory that the Voting Rights Act, wasn't necessary, that the remedies of the Voting Rights Act and the need to protect voting were no longer required. And it reaches a zenith last term at the court when, as many of you may remember, Alabama, in the wake of the state of Alabama, in the wake of the 2020 census, had actually done its redistricting process and eliminated one of the majority districts in the state of Alabama. So where there had traditionally been 2 majority Black districts in the state of Alabama, there was now 1. And clearly the gerrymandering was done in a way that was an attempt to dilute and limit the impact of Black voters in that state. The state of Alabama made an incredible argument in defending their redistricting scheme, in which they actually argued that the Voting Rights Act, because it was supposed to equalize voting, because it was supposed to create equal opportunities to voting, actually mandated that states could not consider race when it came to districting. They said that it was actually racist to consider trying to ensure that there was to be a majority representation in multiple districts for Black voters in Alabama. And of course, this is absurd on its face, given the history of the Voting Rights Act, and that the very reason it was adopted was to ensure that Black voters, had access to the polls. And what is fascinating is that 3 justices, it turned out the majority of the court rejected the argument from the state of Mississippi. 3 justices actually would have accepted their argument and ruled that taking into account race in gerrymandering or in redistricting was prohibited under federal law. That was 3, it wasn't 5. But again, what we see is this kind of canary in the coal mine in terms of the way in which the Supreme Court is dealing with and limiting the ability of people to vote. And of course, I don't need to tell you all, but it's well worth. I think it's well worth saying, just to remind all of us, that voting is really the most fundamental tool that we have to protect civil liberties. If we can't vote and create a government that respects the civil liberties and the civil rights of everyone, then candidly, we just don't have the capacity to do that in many other ways. And so, this ability, by the court to sort of limit the capacity and the ability of everyone to participate in the system equally and be represented equally, ends up creating or fostering and advancing policies that limit access to basic civil rights and civil liberties. The second area that I think where we see the court beginning to have an impact on civil rights and civil liberties is really highlighted by the decision from 2 terms ago now that we're into this new term, 2 terms ago, when the Supreme Court, after 50 years, simply reversed and ripped away the fundamental right of a woman to seek an abortion, and suggested that there was no constitutional right, that it never existed. And literally, and this is, one of the things that we see often with this court is, again, without really an argument, simply in a couple of paragraphs said, well, the previous courts got it wrong, despite the fact that the justices had all gone to the Senate Judiciary Committee and proclaimed their respect for precedent, said that the courts had got it wrong. The court had got it wrong, that there was no fundamental right to an abortion, that Roe was flawed and therefore would be overturned. And we see, I think, both, we see Roe as that kind of tip of the spear when it comes to these issues of kind of bodily autonomy and fundamental privacy. And let me take a moment and sort of expand on that, because it will help me make a larger point. One of the things that the court has done dating back to the early 1960s is that the court has with greater frequency recognized a fundamental notion of liberty for you and I to be able to make fundamental personal decisions without governmental interference. So whether those decisions are about our healthcare, whether they are about how we want to express ourselves, whether they are about whether or not we want to become parents, whom we want to marry, whether or not we want to marry, and how we want to live and organize and orchestrate our lives, the court has increasingly said that those are spheres, that liberty is something that we protect, that the government can't interfere with. What the Dobbs decision with regards to abortion did was really pierce that kind of veil around us when it comes to that personal liberty, that personal thing, those personal concepts. And while a couple of the justices who overturned Roe were at lengths to say that that was all they were doing, what you see in some of the concurring opinions, specifically from Justice Thomas and less so from Justice Gorsuch, is an invitation for others to bring challenges to the court on issues like LGBTQ relationships, sodomy laws, contraception, and whether or not contraception should be widely available, same-sex or marriage equality, and other protections, which, again, people have organized and orchestrated and lived their lives, depending on, in the case of marriage, for almost 10 years, in the case of contraception, for nearly 60 years. And what we see is a court willing to cast those things away, again, under this guise of original intent, originalism, that the Constitution, in the Dobbs case, Justice Alito argues that the constitutional framers could never have contemplated a right to abortion being written into the Constitution. I will just say, as a footnote, as someone who was trained as an historian, Justice Alito gets most of the history wrong, but that is what this court, in pursuing doggedly this notion of originalism seeks to do is to undermine these kinds of basic fundamental rights. And so, whether it's in Illinois, where we've worked to put in protections for all of these things, if the Supreme Court were to, suddenly rule against marriage equality, for example, we passed a law in Illinois, so it would remain the law here. Whether it is on contraception, is putting in place protections for contraception and contraceptive access and coverage in Illinois, because again, these are the kinds of things that if at the federal level the protections disappeared, we are taking the steps that we can as a state to put those protections in place. And so I think, this is an area where I think we all need to be on guard and watch what the court does, watch the cases they take. As many of you will know, who have followed the abortion rights issue, the court has now taken the case around access to mifepristone, the most widely used and safe and effective abortion medication. So we'll see again. The courts said in Dobbs that they were simply the court said they were simply returning this question to the states. Now, with one kind of ruling, we could effectively have a ban nationally on the safest and most widely used abortion medication, which looks much more like a national ban to many of us than it does a state ban. And so we see these kinds of fundamental rights being stripped away, being chipped away at, being used. And the last area that I really want to highlight here is the way in which the court has begun to turn on its head the notion or the concept of religious liberty in a fashion that really does kind of threaten to pull apart or at least fray our basic non-discrimination structure that we've had in place for at least a half a century in the United States. And let me start by saying in this area that, one of the general understandings that we all have is that each of us has a right to worship, to believe, and to express ourselves in terms of our religious nature in whatever fashion we wish. We can worship any religion. We're not forced by government to do that. We can behave in, our religion can be practiced in ways that we think are appropriate. We can't be forced to abide by a particular doctrine or believe a particular thing. But where that has always stopped is really in two fundamental ways. And the first is that when our belief crosses over to action, where we are acting on our religion, that is not necessarily protected, especially as it infringes upon others. And the second and really in many ways most important way is that our religious beliefs are not allowed to supersede or undermine generally acceptable laws that apply to everyone. And there's a whole string of cases that the court has dealt with over the years that deal with this question. So, for example, in many years ago, the court decided a case in which a business owner did not want to abide by equal pay laws for the women who worked for him, because in his view, men were the head of a household. That was his religious belief. And if he paid women an equal sum to men, then the men couldn't care for their families, and that would be against a violation of his religious beliefs. And the court said, you can't do that. These laws apply to everybody. It doesn't matter what religious background you are, and you can't shift those things and allow for a religious belief to trump, forgive the phrase, but to trump the idea of a non-discrimination law that applies to everyone. And that has been the general principle under which we operated until last term of the Supreme Court. And in a case that many of you may have heard of, a case called 303 Creative, a website designer came to the courts, and I'm going to pause on this for just a minute and go a little more into civil procedure than any of you wanted tonight, but came to the courts and said that she designs websites. She'd like to design wedding websites. She doesn't do it now because under Colorado law, if she refused to do websites for same-sex couples, then that would infringe upon her expression, which is driven by her religious beliefs. That was her argument. Normally, and I'm going to underscore the normally part, a case doesn't get decided by a court until someone has been harmed. Courts don't issue advisory opinions. And in this instance, the Supreme Court literally recognized that this person had never been asked to do a website of a same-sex couple. She had never refused to do one. And so no one had been harmed, but she wanted to be assured by the court that she could violate the non-discrimination laws of the state of Colorado, a law very similar to the law here in Illinois, and do so freely without fear of being disciplined. What was fascinating is that the creative website designer argued that the reason that she was protecting this created product was because when she designed a website, she was, quote, telling her story. Now, I've been married for almost 30 years. I'm pretty sure when you do I feel like I know a little bit about marriage, and I think when you do a wedding website, you're telling somebody else's story and not your own. But the court accepted that argument and literally, again, with no harm to anyone, said that because this was an expressive creation of doing a website, that she could determine, who she did and who she didn't want to, you have as a customer, and could discriminate on the basis of a couple being a same-sex couple. That notion that a fundamental non-discrimination law can be violated based on that really opens up a range of possibilities. One of the things that many of you might know historically is that in challenging or defending, I should say in defending Jim Crow laws and pushing it back against challenges to them, white business owners in the South would often say that it was their Christian view that the races should not mix. And courts rejected that time and time and time again. But what this court seems to be willing and open to do is to suggest that if someone says that their religious viewpoint just discriminates against gay and lesbian folks or transgender folks, that might be enough, and that would allow for a limitation in terms of enforcement of non-discrimination laws across the country. And I think one of the ways that we often think about this here at the ACLU of Illinois is in the wake of our civil union law several years ago, we represented a couple downstate who went to a bed and breakfast in order to have a civil union ceremony at the bed and breakfast that said they were open for, quote, civil ceremonies. The owner of the bed and breakfast refused to allow them to have the service there. He then engaged in a 3-week campaign of harassment, telling our clients that they were going to go to hell for their sexuality. But we won that case under the Illinois Human Rights Act. And, one of the things that we thought at the time that was kind of wild was that the owner of the bed and breakfast used to say that he had crafted every room and every area of his bed and breakfast using his God-given gifts, and that if a gay couple were to be solemnized in that space, that they could, that it would violate his religious beliefs. And I don't know what happens to that case if it goes to this Supreme Court. And this idea of the religion being used in this way, I think is one that we could see in a host of other ways, by businesses, by schools, by individual teachers, by individual principals or others, in a way that could really kind of reshape the landscape of what we have expected for many years, again, going back to the 1950s and the 1960s in the federal court. And so I think I think this is yet another way in which the court is beginning to restrict or limit the kinds of concepts to really kind of change the arc of the history that we've seen in the last 50 to 70 years in the United States, in terms of the kind of constricted views of this particular majority on the court. And I'll just say that they are working quickly. They are they are really taking on cases. They are inviting cases. We are seeing groups and entities move cases to get them to this court, to get them to rule on particular things. And I think it's something that we all should be concerned about. So let me close my opening remarks with an observation that may be surprising given the last 30 minutes. But I don't think it's all doom and gloom. And I say that because I think that a lot of what the court is going to do is going to lower the floor of what is constitutionally required. But that doesn't change the fact that in the states or at the local area, we can build larger protections. And I think as we go into this election year and move forward, that one of the things we should be cognizant of is that protecting civil liberties for too much of my adulthood has really been seen as the job of lawyers arguing in federal court and taking cases to the Supreme Court. That is not going to work with this particular court. And instead, what we really need, what is required, in fact, is all of us to engage a much more active citizenship where we are working for protections, for change, for respect for civil rights and civil liberties, not just in the courts and not just at the federal level, but at the state level and even at the local level. even down to school boards and library boards and park district boards. And I think that as we think about how we move forward, we're not going to get the great victories again that, many of us have been accustomed to, and seeing people run out of the Supreme Court waiving decisions and being happy. Protecting civil rights and civil liberties is really going to boil down to the hard work of all of us working together to do that at the state and local level. I believe we can do that work. I think, in fact, that challenge is something that we're up to as citizens. We just need to engage new muscles in the way we do it, and recognize that democracy today is not, and really never has been, a spectator sport. So I think with that, I will stop and take your questions. And if there are other areas of the court's work, if there are other questions about other things that they're doing, I'm happy to take those.
Ed, this is really a question, but maybe you can make a comment to this. Somebody said, state protections help until the Supreme Court reverses again and decides federal law supersedes state law.
It's a good point. That, I think there are some areas and some extremes where that kind of decision, might be one that would be hard to overcome with state protections or local protections. But, and I want to say this, I think that there are ways for us to continue to move those forward. In the abortion rights realm, if in fact the Supreme Court ever, found a fetal personhood, that would be something that I think we'd all be scrambling to try to overcome and see how we would put in state protections. But expecting that they won't go that far, I think there are opportunities for us to continue to build state protections and local protections for as long as we can. But we have to be prepared and be thoughtful for every eventuality. I'm sorry. Here's the thing you'll find out. I try to keep my presentation short because my answers are always too damn long. But here's the thing I always think of. We knew in 2014 that Roe would be scaled back or overturned. We knew it. And so one of the things that, happened in Illinois was that we began by changing, by eliminating the so-called trigger on our abortion law. So there was a 1973 act after Roe that if Roe was ever overturned, Illinois would return to its 65 ban on abortion. So we took that out of the law. And then we wrote and passed the Reproductive Health Act that enshrined in Illinois law a fundamental right for every person in Illinois to make their own decision about every reproductive health care decision. And we did that knowing that if Roe was overturned, we would want those protections to be in place in Illinois. There are other calamities like the end of Roe that we could see coming down. And I can only say that, the good news is that people are working and thinking about the protections we can put in place today to prepare for that day if that should ever come to pass.
Two people have asked if you can give more specific examples of how we can protect our civil liberties at the local level.
Sure. Yeah. I'd love to. This is actually my favorite thing I love to talk about these days. So you know, and again, I'm thinking in this audience, it might not be as significant as when I do this in other places. But let me just say this. We all know who the president of the United States is. We probably all know who our two senators are. We probably all know who represents us in Congress, right? What's really critical is knowing who is a member of your local city council, knowing who's the member of the local library board, knowing who's the member of the local park district board, because here's how those things really get protected at the local level. Think about the policies that can be set, for example, in your local community, in Naperville, just to, you know, like in any community, that advance and protect civil liberties. Everything from a resolution or statement by the governmental entities that they protect civil liberties, that they believe in fundamental rights, that they stand for particular issues. That can be a large thing. Maybe it's something maybe it's something more like, we know in Illinois, like, for example, when it comes to abortion rights, when it comes to gender affirming care these days, Illinois is now an oasis for that kind of care. So maybe it's creating policies that allow for more of that care to be available in your local community. Those things are possible when local officials understand that people will support them. So that's one way. The other way, and I know you guys know this because many of you live in areas that have been at the center of this, but there is this incredible attack on, basic learning, basic information, access to books and curricula and things of that nature. Making sure that you know who your school board members are, that you're voting in those races. And here's the most important thing: showing up to those meetings before there's a controversy and saying what you want. Saying what kind of a school district, what kind of a library system, what kind of a park district that you want that includes everybody and doesn't bar shows because, doesn't bar events at the park district because there's a drag show, that has books and curricula that is inclusive and allows everybody to be seen and be heard. Those are all things that we can do at the local level, along with, making sure that we're supporting candidates for the state legislature who are reflecting our values or your values, whatever those are, when it comes to votes in Springfield. Because I always say, as someone who works on civil liberties issues, the one thing that I can always be assured of is the people who want to listen to civil liberty or want to limit civil liberties, they're always heard from. They're always speaking out. They're always organizing, and they're always present. We need to be, if you believe in those things, we need to be present as well. We need to show up. We need to speak and say what we want. And I'll stop here soon. But one last thing I would just encourage you all to do is, I think it's one of the things of getting older. I think I reflect more on things. I think one of the things that's often a shame is we spend a lot of time saying what we're against. We have to say what we're for more often. And I really would encourage people to think about, in your local community, what's the thing you want? What is the thing that would help? What's the thing that would make it a better, a more welcoming, a more inclusive place? And work for that policy. The truth is that that's going to make more of a difference in your life than what happens in Washington, D.C. And so, I think that those are the kinds of steps we can be taking at the state and local level that really make a difference. I know I said that's my last thing. I'm going to say one more thing. When you work for those policies, when changes get made, we need to thank the people who support them. I was reminded by a member of Congress recently that who mentioned to me, I thanked them for a vote they had taken in November And they said, yeah, it would have been nice to get a letter. And not in a snarky way, but just the reality is that we sometimes ask people to take hard votes. We ask people to do big things. We ask them to support policies. We ought to thank them for doing that as well. And I think at the local level, especially where these are the kinds of folks that you're not just going to see at a public meeting, but you're more likely to see at a soccer game or at the grocery store or at the gas station, making those relationships and thanking people is an incredibly important thing to do.
Thank you. We would like to hear your thoughts on extending the recent decision on affirmative action universities to corporations and businesses.
Yeah, a great question. And there is not anything in the decision that automatically extends it or applies it to to private entities. That's the legal analysis. But what I think is of concern is that the entities who want to work against more inclusory policies believe they now have license and a pathway to challenge those policies, whether they're done at the corporate level or the private level or in any other setting, in the same way as the court ultimately ruled against these practices at the university and educational setting. And so I think that the challenge here is number one, to ensure that if you're at a corporation, if you're part of a corporate setting or a private setting of some sort, that you continue to send the message that you support, whether it's businesses or other corporate settings, that you continue to support those policies, because I think those challenges are going to continue to come. I think it's inevitable with this sort of ruling. And it's been really troubling to see, frankly, early on, the way in which, entities that provide startup funds for minority-owned businesses have been attacked, and other kind of corporate DEI measures have come under the microscope. I think there's going to have to be a broader kind of civic pushback against those, when it comes to being able to ensure that these limitations that we've seen, at the college and university settings aren't extended to a whole range of other things. I will just also add, as just a side note in this, I think it's going to be really, really important that people are creative, as we've seen, that people are creative in terms of thinking about, the way they're going to challenge some of this with, for example, challenges to legacy acceptances and legacy arrangements. So I think it's going to take a whole range of creative thinking. But I have no doubt that the people who ensured that this challenge got to the Supreme Court are going to work tirelessly to get other challenges to get there as well.
Thanks. The next one is, can you talk about the threat the Comstock Act poses today with the current GOP? Yes.
Thanks. So just as a level setting matter, the Comstock Act is a law from the 1850s, which was passed by Congress and signed into law, which effectively barred the transmission through the postal, through the mail of materials that were considered to be obscene. And ultimately that was extended to materials, for example, that provided information on contraception or delaying pregnancy or avoiding pregnancy, or materials that did that. You know, it is, I suppose we could all laugh at the fact that there's an effort underway to suggest that the Comstock Act from the 19th century somehow applies, you know, to the 21st century. But here we are, and this is the argument that's being used. I think in terms of the threat, it comes in a couple of different forms. The first one is, and I've done my thumb, so it does that on the screen. Forgive me. The first threat is that in the mifepristone debate and surrounding other kinds of both contraceptives and abortion medications, the threat is that a different administration, especially a different FDA, could cite the Comstock Act as a reason to bar the transmission of those medications across state lines, specifically state lines where abortion is limited or all out banned. I think that is the most practical limitation. And I think that one of the other things, if we're just thinking about where the threats come, if that threat is real when it comes to abortion medications, you could see an effort to extend it to contraception and contraceptives as well. So I think that kind of class of things under the Comstock Act is one area where you know, that we're going to see a pushback. Now, I will say the Department of Justice has issued a memorandum pointing out that the Comstock Act has never been enforced in that way, or has it ever really been, and certainly has not even been enforced practically for more than 100 years. And so the idea that that's going to be the thing that's going to be utilized today is somewhat troubling. I think that's one area where it could be. Here's the second thing, and we're seeing this a little bit even in Illinois, which is that there is a kind of a small band of anti-abortion lawyers who are claiming that the Comstock Act supersedes state law. And so some of you may have heard that in two communities in Illinois, first in Danville and then in Quincy, there have been efforts to pass local ordinances that would seek to bar, any kinds of materials coming into the community that could be used in abortion, medications and others, citing to the Comstock Act. I don't think that there's those aren't really credible. They're not enforced in those two communities. In Danville, they passed it, but then they passed some bizarre enforcement mechanism, so it didn't go into effect. Quincy rejected it. But I think this idea that even in states that protect abortion rights, that you could start to get pockets of places relying on the Comstock Act that would attempt to limit access to abortion care and contraceptive care and other kinds of health care. I think though that is another area of threat, that if this theory, if that's what we want to call it, would ever really take root, I think that would be the other place where we might all be concerned in terms of what that would mean over the long run. Again, I think the idea that this, statute from the 1850s that hasn't been enforced for years is going to guide our lives today doesn't seem very practical. But I think you're right to ask the question and for us to at least be attuned to what those threats might be.
Thank you. The next question is a little bit long, but gun safety is an issue that impacts women and children. Illinois has protective laws banning the sale of assault weapons and ammunition. Other states want unregistered guns allowed by open carry laws. Do you have any insight into the current court as to the amount of interference in our gun safety laws at the state level?
It's a really, really good question. It's a really good question. I think So let me start out by saying that I think the one insight that I would offer is I think the recent Bruner ruling from New York about concealed carry in New York is an interesting, gives you an interesting insight in that this court does seem to find both this individual right to guns and carrying guns, and that in a way that has really never been seen before. And I think that's a little bit startling, for many, and I think a little disturbing. But there's been an interesting development just in the last few weeks, which, as you know, in advance of the Illinois ban on assault weapons going into effect, there were several efforts to get both the ban, the registry, and other parts of the law in front of the Supreme Court and have them hear that challenge to our new assault weapon ban. The court won't take those cases. They've rejected every single effort to get that law up in front of the court. And I think that there's a couple of theories that I hear from people about this. I think number one, it may be that the court feels like they've gone as far as they can on guns by creating an individual right, by creating, this right to carry. I think that that's one thing, and they don't want to go any further. And I think the other theory is just that that there is some view in the court, especially in the wake of Dobbs, when many of them did not feel safe, that they're concerned about messing around on the assault weapons issue. I don't know which is true. I don't know which holds sway, but it does look to me like, at least for the moment, they seem prone to allow for states to have at least assault weapon bans. Now, whether or not they'll do anything more, I don't know. And then the last thing I'll say is, many of you know, there is a case in front of the court this term having to do with denying guns to someone who's had a restraining order against them. And the court, this is always dangerous, but I'll just say, in oral arguments, the court seemed not to want to reverse those bans, recognizing the impact that could have, especially the threat that it poses to women who are survivors of domestic violence. So, I think that case, and then whether or not they take an assault ban case or assault weapons case, I think those two things are things to watch to really get an insight on where they're going to go from here. I mean, I will say, on a personal level, this is not an area that the ACLU often weighs in on. I feel like they've gone far enough, but I think those two things will really give some insight into where we go next.
Thank you. And last question is, in one of your previous responses, you said that there were some calamities that on the horizon. What are they?
Oh, wow. Well, we should always end on a high note, huh? Okay, let me talk about two of them. I'm sorry, let me talk about three things that is sort of quickly, maybe the last one not so quickly. But I think the first one is that I believe that, you know, there are efforts that are well underway to get a challenge to Obergefell, to the marriage equality ruling of a few years ago back in front of the Supreme Court. I think opponents of marriage equality believe that if they could get that case in front of the court, that they could get a majority of the court to rule that the court got it wrong and there isn't a constitutional right to liberty to decide who you want to marry. I think that would be a calamity because, as you know, in many states, not Illinois, but in many states, marriage came through court rulings. Marriage came through rulings by either the Supreme Court and then states allowed it, or by local federal courts that opened up access to marriage licenses for all couples. I think it would create real havoc and chaos if we went back to a place where people could get married just in some states and not in others, and be recognized in a few, but not in every state, where adoptions or children might well be considered, not covered by parental rights. I think there's a whole host of things in that realm that would truly be a calamity. And so that's one of them that I think of. There are efforts candidly underway. I don't think they'll be successful, but often wrong, never in doubt, as they say. But I think there are efforts underway to get a personhood case, a fetal personhood case, to the Supreme Court. Were the court to ever rule that, obviously state protections that have been put in place in Illinois, in New York, in California, in Michigan, in other states, what we're seeing happen at the ballot box in many places, including most recently Ohio. All of that could be reversed. I think I'm one of the reasons I'm less sanguine about that actually happening is, I think, as the old saying goes, the Supreme Court does read the election results. It's hard not to read what happened in Ohio and Michigan and Kansas and Kentucky and other places, where when you put this fundamental question to a vote, the American people turn out and want to have a right to decide about their own health care and their own futures. And so I think that's one that I think would be a calamity. Here's one that's not exactly a civil liberties issue. And there's actually a case up this year that could really impact this. And I think it would be a calamity in many ways. And that is if fundamentally the court overturns the so-called Chevron doctrine. And in short, and again, sorry for using the insider baseball language, but in short, our Congress passes laws that prescribe broad general kinds of principles, and those are broad general things that the government wants to do. We want clean water, right? We want to have forests cut in a way that protects the environment. We want for manufacturing to be able to go forward, but with certain kinds of safety provisions and other protections that mean that workers don't get hurt, that products are safe. We want to protect certain kinds of resources so that when we turn the tap on, the water is safe, the water is healthy. These are things that, we take for granted in many ways. And that it's really important that we have. But what we don't expect is that Congress is going to define how that works in real detail. That Congress is not going to be the ones, because they're not experts. And then instead, what we do is we have a body of experts within our government who make decisions about how we get to the goals that Congress sets. And the Chevron doctrine is essentially a decision from a number of years ago by the Supreme Court that said, for all intents and purposes, that when Congress acts, they are really ceding authority to the agencies to carry out their wishes, and Congress could act to overrule them or to overturn them, but they gave broad powers to the agencies to implement specifics of regulations to meet the goals that Congress has created in broad strokes. This term, the court has a case in which they seem poised to overturn the Chevron doctrine and to suggest that if Congress wants us to have clean tap water, then Congress has to tell us exactly how to do it. Well, I don't know if you've noticed lately, but Congress is not really good at doing things. They're not good at paying bills. They're not good at passing budgets. They're not that great at electing a speaker, as it happens for most of this year. And so the idea that 535, if you count the Senate, people are going to come together on specificity to say how we ensure, or have expertise to say how we ensure, how we keep the waters clean, how we keep the forests going, how we make sure the roads are safe. I mean, just to not to put too fine a point on it, we have members of the U.S. House of Representatives who believe in space lasers, controlled by certain religious groups. So the idea somehow that Congress can do this work, what it means is that these regulations grind to a halt. And it really frees up corporate entities essentially to behave and act in whatever ways they wish. And that is, on the part of many who have pushed this agenda for years, their desire. I personally, and I'll just say that again, this is not really an ACLU issue, so forgive me and thank you for indulging me on this. I think that's a calamity. I think the idea that the Supreme Court is going to upend expertise in order to serve, some corporate interest is really a thing which is going to, may not affect my life, frankly, given my age, but in 30 years or 40 years may affect the lives of my son or my grandchild's, et cetera. And that's one of those things that really concerns me. And again, I think we often, pay attention to the highlight the cases about, the Muslim ban or abortion or contraception or LGBT issues. This is one that could really fundamentally reshape our lives in many ways. And I think really deserves a lot more of attention when it comes to these issues.
Thanks. Just a couple comments. If Oberg falls, wouldn't Loving fall as well? And then where would Thomas be? And also, Chevron is ironic since Gorsuch's mother was involved in Chevron to begin with.
Yes, I thank you for making that point. It is unusual, and it will I think Justice Gorsuch, if he were able to write the opinion overturning it, will be there happily. It was interesting, as some observed, that when Justice Thomas wrote his concurring opinion in Dobbs inviting a number of cases to come back to the court, he somehow managed to leave Loving off that list. I'll leave it to all of you to decide why that might have been or what the impact of that might be. But he somehow sees the issue of interracial marriage as being fundamentally different than the issue of marriage equality or gay or lesbian couples. So it's an interesting observation. Some might say he has a personal interest in that.
Okay, that's all of our questions. So thank you very much. It's been very enlightening, very interesting. I love all your asides too, because we learned from those.
Well, thank you, and thanks for staying in tonight in order to do this. I appreciate it. I will just close by sort of the first question I got. And I will just say, it was Congressman Mike Quigley recently made the observation to me that all politics are national until they're not. And I think that really is sort of my driving theory for 2024, that the work we have to do is really at the state and local level. It's where we can have the most impact. It's where we can do the most good. We just need to go out and do it.
Thank you. And
Thank
go
you very
home
much.
safely.
Thank you. Take care, everybody.
That concludes the meeting. So thank you, everybody, for joining. I hope you got a lot out of it.
Thank you, Ann.